Eve- Good evening.
Good evening. Thank you for being here. Good evening.
Thank you for having this.
Oh, good. I'm glad people are excited about it. It's important information. And maybe excited is not the right word. Necessary information. Still admitting folks, so I just want to give them a minute. All right, I'm going to get started. I don't see any more folks in the wait room. Well, good evening, everyone. Thank you so much for being here with us this evening. My name is Roseanne Santos. I am the Director of Alumni Engagement at John Jay College. I've been at the college for about 15 years, and I love doing this work. I get to meet folks like your speaker this evening, and I get to meet many of you in some way, shape, or form. If today's my first time meeting you, welcome. If you've met me before, good to see you, and we're going to have an amazing conversation. Before I introduce Mr. Lamberti, I do want to share that he is going to give his presentation and we're going to keep the questions until the end because it could be that he probably has an answer for you as he's going. So write them down, jot them down, and just hold on to them. Be patient because I know that they're going to be fantastic questions. And if you want to put them in the chat, that's okay too. So let's meet our speaker. Mr. Anthony J. Lamberti, Esquire, is a respected attorney and partner at Armstrong and Lamberti with offices in Brooklyn and Staten Island. He is a graduate of John Jay College and Brooklyn Law Schools, and his practice focuses on elder law, guardianships, trusts, and estates. I also want to mention that he is a two-time inductee into the Athletics Hall of Fame at John Jay. He was on the baseball team that was inducted into the Hall of Fame last year, and he was inducted as an individual player. So we have a lot of history with Mr. Lamberti, and we are so honored that he's here with us this evening. Lifelong Brooklyn resident, very proud to be part of John Jay. He's a frequent lecturer on the concept of guardianship and elder law issues. He brings compassion and expertise to these very complex legal matters that impact families and older adults every day. And with that, I'm going to stop sharing so we can spotlight Mr. Lamberti. I ask that you all keep yourselves on mute until the Q&A time comes around and I call your name. If you have any technical issues, just send me a private message through the chat and I will assist as much as possible. And anything else, any other questions or anything of the nature, again, use the chat because we don't want any background noise while Mr. Lamberti is giving his presentation. So thank you everyone again for being here. And let's get the show on the road. Let me spotlight him, giving him the attention he deserves. Mr. Lamberti, the floor is yours.
Thank you. Thank you, Ms. Santos. Good evening, everybody. Uh, Thank you for taking the time to uh, join us this evening. Uh, the name of this program is Demystifying Estate Planning. And hopefully, what I'm going to talk about this evening will clarify some things that you might be aware of, but don't have all the answers to. And it may be able to answer some of your questions about things that you may be going on in your own life, and also may be able to clarify things that you might have misconceptions about. Just as a general starting place, elder law has not been a practice area. The New York State Bar did not recognize it as a section until 1988. Now, I remember, taking classes, law classes at John Jay and in law school. And, you talk about jurisprudence. Uh, you know, I remember in law school reading contract cases from the 17 and 1800s. So in the realm of law, elder law as its standalone section is relatively new in scope. So with that, I'm going to start off with some basics and work into some more complex issues. First thing is what we call basic planning and advanced directives. Now, at a minimum, these documents that I'm going to speak about right now, at a minimum, some are things that you should have because they're absolutely necessary. First off, power of attorney. Now, power of attorney is a document in which you are designating an agent to act on your behalf for financial matters. Normally, with this document, we have an alternate named in the document. God forbid something happens to your agent, they can't act, can't be reached, they're out of the country, whatever it is, you have an alternate there who can act. The other important thing, not just with the power of attorney document, but with any of these documents, the person that you name, you should speak to them in advance to make sure they want to do this, particularly with the next two documents that I'm going to segue into, healthcare proxy and living will. Now, a healthcare proxy is a document that you're naming an agent to make healthcare decisions for you, even if you're temporarily incapacitated. Now, everybody, if you have children, if you have a relative that you might think about being the person you might want to have to be this agent in this context, make sure you ask them, because the worst thing you want to have happen to you is if you're in this predicament where you can't make a healthcare decision for yourself and your agent, just is unwilling or just can't, freezes up at the thought of, I got to make a decision about my mom or my dad. I just can't do it. And I tell everybody, your own relatives, family member, friend, whoever you're going to think about doing this, make sure you ask them and reiterate with them the importance of not backing out at the 11th hour. The living will is a document that you are stating your intentions if you're in a life extremist situation. So many of you are, probably heard about these right to die cases. There's a case in New Jersey some years ago, Karen Ann Quinlan. There was a dispute about taking her off life sustaining treatment and things of that nature. Your living will is a statement of your intentions about what you may or may not want if you're in a life extremist situation. Next document is a burial agent designation. Now you say, "Oh wow, what does that mean? What happens with that document?" Well, it's a relatively new document. The funeral directors pushed for this document, and they got it through. And quite frankly, I think they were tired of dealing with family disputes in the funeral homes. And this document, you're naming an agent to make your funeral arrangements. Now, having been through this many times over the years with my own family, even if you go and prepay a funeral, which is another option, people can go and do that. At the time of death, the funeral director has to sit with someone because there is information that goes on the death certificate that has to be done. Otherwise, the city will not issue a death certificate. So this is an important document. We also do medical record authorizations. The most common reason for medical record authorizations sometimes is the need for getting records if there's an insurance claim. The other one is, and it comes up from time to time, if there's some kind of accident or lawsuit and personal injuries are part of the claims to recover money, the medical records are necessary to be able to promulgate a lawsuit. Last basic document we do is a will. Now, your will is a document that you're stating who you want to handle your affairs after your demise. And again, relative, friend, it doesn't matter. It's your choice. It's your document. And it also sets forth who you want to get your assets post-death. Now, I'm going to get into some of these other things about more complex planning in a few minutes. But at a minimum, these basic documents are something that you should seriously consider. Now, let's go on to now the next phase. If you don't have these basic documents, and what happens if something arises and you become incapacitated? And this is when we talk about guardianship in New York State under Article 81 of the Mental Hygiene Law. Guardianship under that statute is primarily for adults. An adult in New York is over 18 years of age. And it's a very complex statute. As strange as it sounds, just because you have a condition, like let's say dementia, it doesn't mean you get a guardian. You need to set forth factual allegations in a petition to the court as to what the person's deficits are. We're getting the first cold spell of the year. I saw on the news a little while ago. So if somebody's out and about walking in the neighborhood in the overnight hours or early tomorrow morning in shorts, flip-flops, and a T-shirt, you might have some doubt about that person's capacity. That in and of itself doesn't get a person a guardian, but it's accumulation of things. If that person's walking around on the street and doesn't go home for a few hours, or is in the local McDonald's, or they bounce all their checks, etc. Accumulation of inability to perform activities of daily living gets you over the threshold when you file a petition for guardianship. Now, these advanced directives that I just mentioned are considered resources under the statute. So if a person has these documents, as I outlined a few moments ago, they may not need a guardian under our law. The courts don't want to have thousands of guardianships, and in some counties in New York City, there are thousands of open guardianship cases, existing guardianship cases. But the resource component takes a lot of cases out of the court and the need for court intervention. Now, ultimately, there's a hearing before the court. Now, sometimes the petitioner is a family member, in which case the court will scrutinize whether or not they should be the one to handle your affairs. There is a preponderance or strong consideration that family members should be the person to be guardian for a family member, but there may be a lot of reasons that they may not be considered. One of the most significant ones is bonding. Now, bonding is an insurance policy, and it's generally done to protect the incapacitated person's assets. So let's say a person has $200,000. The court may bond someone who's going to be a guardian, because if the money disappears, they want to make sure that the guardianship could get that money back and there's money to take care of the person. So the inability to be bonded sometimes is a big factor in guardianship with family members. Now, under the law that exists with Article 81, there's a broad range of entities that can file for guardianship. A hospital or a nursing home can file for guardianship if a person is a patient or a resident there. The Department of Social Service can file for guardianship through their agency protective service for adults. So there's a broad spectrum of entities that can file. And again, it's up to the court after a hearing to determine first whether the person is incapacitated. And if they are, who's the best person to serve? Now, over the years of doing this work, I've been appointed guardian from time to time. There are folks out there that don't have any relatives or any reliable relatives, or the relatives that could help them are sometimes even older than they are. And it's difficult to have that circumstance where they would be providing help. So the court leans on elder lawyers, social workers, nurses to take on these assignments. More and more cases where the person is living in the community are happening, and they're the most difficult cases to handle. Many of the cases now, we have geriatric care managers that routinely get appointed together with a guardian to try to create the best possible plan to take care of the elderly person. But this has become we're an aging population. The demographics the numbers are just increasing, and if you don't plan, this is going to be taken potentially out of your hands. That who will be handling your affairs? And the last negative part of guardianship is it's costly and time consuming. Walking into a courthouse these days, filing petitions, appearing for hearings, preparing orders, accounting for the money every year, getting examined by the court when you're the guardian, etc. This costs a lot of money. And if you plan and you have these resources, as I've outlined with the basic documents, you'd be a long way to avoiding guardianship, which, as an attorney advising clients, this is probably one of the biggest things that I try to steer people to do. At a minimum, do the documents. Right now, let's talk about now what happens if you become ill and you need care. And a lot of us think that I have health insurance, I have Medicare, I'm taken care of. Now, Medicare does not totally pay for long-term care. It only pays for a short amount of time after you're in a hospital and discharged. If you're discharged home, they may give you a maximum of 8 weeks of home care, anywhere from 4 to 8 hours a day. And that's not a heck of a lot. If you need care and you don't have anybody to assist you at home, spouse, loved one, significant other family member, that's not a lot of care. There's 16 other hours in the day that you may need help, or somebody may need help. So Medicare is not the answer. Some people have taken long-term care insurance out. Quite frankly, it was a big product. I'd say about 20 years ago, there was a big push by insurance companies to, put out the word, big sales pitches, and companies had tremendous amounts of meetings and lectures and literature, but the product didn't really take off. And there were a number of companies that have dropped out of the underwriting of it completely. And right now, I think there's only 2 companies left in New York that are underwriting it, and it's very expensive. If if you're older than 50 years of age, the premiums are going to cost you considerable amount of money. If you're younger than 50 years of age, and you wanted to take out the premium, take out the policy, the premiums may be reasonable, but you're going to be paying for them conceivably a very long time, 20, 25 years. So it's a product that's out there, but hasn't gotten much traction. And the amount of the payouts are not matching what the cost of care is out there now. So the next thing is, do you think about privately paying for your care? So let's talk about that from just dollars. Home care with an agency is roughly between $30 and $35 an hour. An 8-hour day, if you had home care for 8 hours and you were paying for it, that's around $250 a day. You multiply that by 30 days for the month. If you need it every day, that's $7,500 a month. That's a considerable amount of money. A facility, nursing homes are costing $600 and $700 a day. We have one facility in Staten Island is up to $750 a day. So you're looking at $18,000 to $20,000 per month. With those kind of numbers, you're approaching $250,000 a year for private paying for care. The last option is Medicaid. And do you seek to endeavor to make yourself eligible to receive Medicaid benefits if you need care? Now, Medicaid has very complex rules. There's a volume of the New York Code of Rules and Regulations just for the social service law, and it's 8 volumes. And that's what covers all the Medicaid regulations. They make these rules very, very complex and difficult to scare off people from even doing this. Medicaid has asset limits. Now, the asset limits are, they fluctuate depending upon the year. Every year they seem to increase them slightly. So an individual, single person, it's roughly $32,000 is the asset limit. So if you have a bank account, if you own a real property or you own a co-op, you have more than $32,000. Married couples are not allowed to have all that much more, between $75,000 and $125,000, depending upon how your assets are held. There is a homestead exemption for married persons. If one spouse needs the care, they don't count the home in the asset calculation. So there are some favorable things for spouses in terms of what the rules are. There are income limits. $900 for a single person in a home care setting. Nursing home, you're allowed to have up to $3,800, but they take your assets if you need care. So it's a very complex set of rules that you're dealing with when you're dealing with the Medicaid. And generally speaking, the next problem or hurdle with dealing with Medicaid is the look-back periods. Now, Medicaid has a 5-year look-back for nursing home care. Now, what that means is if you transfer your assets tomorrow technically not eligible for Medicaid in a skilled nursing facility for 5 years. So we're talking about not being eligible until 2030. It seems like a long way off, but believe it or not, I mean, done these plans for people over the years. People call us up and, we look back and maybe we transferred the house and we said, wow, we can't believe 5 years have passed, or, 4 years and 8 months have passed from when we did that transfer. So planning is the key with Medicaid. Now, transferring assets creates ineligibility. That 5-year look back is for skilled nursing care. Right now, we're functioning with a 1-month look back for home care. Now, home care is a little bit daunting for people. You're going to have folks come into your home. I know in doing this over the years, a lot of families opt for privately engaging people to come into their home, as opposed to having Medicaid people come into the home. Now, this 1-month look back sounds great. So if you transferred everything tomorrow in December, you're eligible to have home care. However, in a home care situation, you have to meet the criteria of not being able to perform at least 3 activities of daily living per day. And this isn't determined by your doctor. This is determined by Medicaid having this independent medical assessor entity that they use. So, again, it's made to be difficult. The backlog with these applications on months. You file a home care application in December, you might not get approval till February or March. So there's always this lag time of the outset if you need care. Now, there are a lot of misconceptions about that type of thing of, it's going to take me 3 or 4 months, maybe I shouldn't apply. There is something called immediate need. If care is needed imminently, and you could establish that, again, with this independent assessor. And usually that immediate need deals with many activities of daily living being unable to be performed. So it's not something that's just given because you check the box and say immediate need on the application. They're going to come out and assess it, and they make a determination. And the whole appeals process, that too is very complex and daunting for lay people. It's even complex and daunting for attorneys who don't do this regularly. And some of us who do this, many people, elder law attorneys, don't get involved in doing fair hearings anymore because it takes so long to get the hearing. It takes so long to get a decision rendered that it's almost worth it to advise your client to, sit back and reapply, because circumstances may be different in a month or two. You get a different assessor who will look at something differently. So it's a very it's a very complex and difficult system to navigate. Now, there are certain transfers that are considered exempt under the rules. So a transfer between spouses is exempt. So you could transfer your house to your spouse, and Medicaid will not look at that and count that as a penalty. You can You could also transfer assets to a disabled child. Sometimes that disabled child, because they're getting benefits, it has to be done in a certain way, in a certain type of trust. But that's a mechanism to exempt assets and transfer and hasten your eligibility to get Medicaid. Last exemption is a caretaker child. Now we say, oh, caretaker child. Well, my son or daughter comes over and takes me, food shopping or whatever, and they take me to my doctor appointments. Caretaker child has to live in the real property that you own for at least 2 years from the time of the transfer. So, we try to encourage people who have a child living at home, and more people seem to have children coming back to live with them for various reasons. And this is a mechanism to exempt assets with no look back period. And it's, again, talking about doing some of these transfers and of assets and things, over the years of doing this, I've always jokingly said that my law office is, part law office and part confessional. People tell me all kinds of reasons why they don't want to transfer assets to their kids. They don't like their son or daughter-in-law. Their son drinks. He goes to Atlantic City. He's got a girlfriend on the side. I don't like his business partner. You name something you can think of, and I probably have heard it from a parent as a reason why they don't want to transfer assets to their children. So it's a very difficult thing. Now, that goes part and parcel with these transfers have to be, done and in essence irrevocable, because that's the Medicaid rules. You can't, you can't like dangle it on a stick and say, I'm going to put it out there and you can have it. But then I'm going to take it back. The ability to take it back, Medicaid doesn't count that as a transfer. So a lot of people have done things, or the other one that you hear a lot of. Well, I put my son or daughter on my bank account. Isn't that account now my son or daughter's? Yes and no. Under the banking law, they can go into the bank account if it's a joint account, and they can transact on the account. But Medicaid and that 8-volume set that they have has a regulation about this, and they deem any account that an applicant is on to belong to the applicant and be counted as their resources. So when we talk to folks about doing plans and doing things, we have to get all of your assets. We even ask for tax returns. We look at everything, because something you may think is innocuous. Life insurance, for example. Depending on the type of policy you have, you might have cash value in your life insurance. Medicaid counts that as part of the resources that they assess. So it's important that whoever you meet with, you have to give them as complete an asset picture as you can. Now, those are the rules, but now we're going to talk about, some more complex planning. Trusts aren't just for rich people. You may think, well, I don't have $20 million. I don't have $2 million. Why do I need a trust? If you have real property, if maybe you have a brokerage account, you may need a trust, because that's one way we can protect your assets with this 5-year look back. Now, there's certain kinds of trusts. A revocable trust is one that you can, as its title implies, you could revoke it and end it at any time. That trust doesn't work for Medicaid purposes, because you could take the money back, or the house back, or the brokerage account back. That trust will avoid probate after you pass, and will quickly pass your assets to who you name as your beneficiary, but it will not protect your assets from Medicaid. Medicaid has what's called, in their rules, it's an irrevocable Medicaid income-only trust. Now, that's a mouthful, because it is a mouthful. Irrevocable, as its terms, the title says, it's irrevocable. There are very limited statutory circumstances where you can revoke an irrevocable trust. There, again, circumstances that are, in my years of practice, I'd say it's 35 years of practicing, it's maybe come up 10 times where we've met the criteria to revoke an irrevocable trust under the terms of the statute. Income only. Now, when we routinely draft these trusts, we provide that the income can be reinvested if there's no Medicaid being paid to the applicant, to the creator of the trust. But if the person is on Medicaid, they have to get all of the income from that trust. So, for example, if there's a 4-family house and it's in the trust, the trust could operate, the trust can do what it has to do to pay the bills and pay the taxes and insurance, and the money could sit in the trust and accumulate because nobody's applied for Medicaid. But if the grantor of that trust creates this trust and now needs Medicaid to pay for either home care or facility care, that income is available in the calculation of your resources under the Medicaid rules. So that's something, again, because people like to keep control of their assets, and I'm gonna, I'm saying this myself. I do this for a living. I give advice to people. I still haven't transferred my own assets because I love my kids, but I'm not ready to give them control of my assets. I still practice law. I have an office to run. I have, a revenue stream. I'm not, at this point in time, I'm not taking advantage of these rules because I'm not ready for it because of the totality of my circumstances, and everybody has got different circumstances. Transferring houses. People talk about, what should I do? Should I transfer my house? Usually the first question I ask is, if we put your house into a trust, is the house going to ever be sold during your lifetime? Now, some people say, no, I love my house. We're not going to sell the house. I'm staying in my house. That person's a candidate for the trust. But if they tell me, oh, well, I really don't like the cold weather. I have a condo in Florida that I'm going to go to, and I'm probably going to sell in a couple of years. That's not a situation that I would advise about putting the property into to the irrevocable trust, because you're tying up the property, you're tying up the assets. Even if you sell it, it's got to go back into this trust. There may be impacts to capital gains when you sell a property. So there's a lot of things that go into creating a plan for someone. It's not a cookie cutter. Everybody doesn't walk in and say, okay, let's give them a trust. We might use a trust as one of the tools in the toolbox, but a lot more inquiry has to get made about their asset picture and different things. I want to segue just for a second to when we're talking about assets and things. I want to talk about IRAs and 401ks, and over the years of doing this, when I was a New York State court officer before I went to law school. I have a lot of my friends are police officers. I went to John Jay. A lot of my baseball teammates were police officers, firemen, and they talk to me, and I know you have that the annuity you get and all that stuff. We don't transfer qualified plans, IRAs, 401ks, 403bs, things of that nature, because we don't want to create tax events. In doing Medicaid planning, we can protect your assets. We can't protect your income stream. Now, there's a lot of different reasons why this is, but these are the rules. I don't make the rules. I didn't make the rules. I'm just trying to help you work around the rules to take advantage. And in some circumstances, I don't know. Over my years of doing this, I could maybe count once or twice a year where I have prospective clients walk into my office and say they're ready to privately pay, and they have enough resources to pay $200,000 a year if they end up in a nursing home. It just doesn't happen, and Medicaid becomes the mechanism that we have to use to get people the care that they need and to pay for that care.
Anthony, I just want to give you a time check. It's
Yep.
6:45.
Okay.
There are some questions that have come to me in the chat.
Okay. I'm close to.
Okay.
I'm close to
Just
the
wanted
end.
to give you a heads up.
It's okay. Thank you. All right. So we're talking about these trusts, and I just mentioned those other types of assets. The qualified assets. Make sure you have your beneficiaries current and up to date. Life insurance, IRAs, all of these things, because if you don't have them updated, the case law has been, over the years with these things that pop up, the beneficiary designation says I leave it to my wife, and they're either divorced, and now he doesn't have a wife. Who gets it? You got to go to surrogate's court and figure this out. And now you're in probate, which could take quite some time depending upon, what county you live in New York State. As I mentioned before, the trusts avoid probate for the assets you put into the trust. And the trust is a private document. We don't have to record it anywhere. We don't have to do anything like that. In trust for account, ITF, they write on the title when you get the statement. You can designate someone to get that account at the time of your death. All they have to do is go in with a death certificate and present it to the bank, and the bank will issue them a check. That's a way to avoid probate also. Brokerage accounts. If you have a brokerage account, brokerage accounts are a little different. They don't use the ITF. They use transfer on death, TOD, as the mechanism to designate someone to get that account at the time of death by presentment of a death certificate. Last thing I wanted to mention, we talked about wills, we talked about these trusts. A trust is a substitute for a will. Anything you put in a trust could be distributed post-death because it's a private document, so long as it's titled into the trust. And just like in a will, you could do a lot of things with who you want to get your assets or entities you want to get your assets. Now, I know from now being on this lecture tonight, many of us have been involved in John Jay for quite some time. Myself, this year, 2025, is the 50th anniversary of me playing my first college baseball game for John Jay. So I've been around a long time. I have made my share of charitable gifts to the athletic department over the years. And one way you can, recognize our institution is by making a gift in your will or in your trust. It's a charitable gift. Charitable gifts reduce your potential for estate tax. They're a way to show some appreciation for your alma mater. I know that many of you, myself included, we probably owe some untold debt of gratitude to John Jay for where we've gotten in our respective careers. So if you are planning to do something like this, think about a charitable donation in your will or in your trust, so that and it doesn't have to be a percentage. It can be a specific amount, and believe me, the college appreciates it. All right, Roseanne.
Well, thank you so much for everything and for adding that last piece. Planned giving to John Jay College Foundation is just that. It's a special gift to the college. And, that will honor the legacy, that will honor your legacy in life and advance opportunities for students. And I'll put up a slide in a moment if you're interested and you want to ask questions about it with some contact information. But I want to be respectful of everyone's time. And Anthony, what I'm going to do is I'm going to read the 3 or 4 questions, and that way you can turn them into a conversation. They might relate to one another.
Sure.
I think that will help with the time.
Okay.
One person asked if you could share or tell us where we could look for sample documents so we know what these documents look like.
Okay.
Someone also asked, do I have to obtain an attorney to set up a trust? And there was one more. Where is it? Oh, can you tell us more about probate and why you want to avoid it if involving a home?
Okay. All right. So in terms of the documents, if you go online, the healthcare proxy is definitely online. It's under the New York Public Health Law. Power of attorney document is online. You should use something that is from the New York State Bar Association, because they have promulgated a form that's recognizable to a lot of financial institutions. Some of these other forms, you might be able to find a medical record document. You might be able to find a medical record document, authorization on the internet. Let's see. I wouldn't suggest you do a will from a document you pull off the internet, because a will has to be um, prepared and signed in conformity with the statute of wills, which is in the estate powers and trust law in New York State. And a lot of people who do wills on their own, a lot of times they don't pass muster to go through probate.
Is that true for a trust as well?
Yeah, well, I'm going to get to a trust now. A trust also, similarly, you can find these forms on the internet. You should get some advice about what assets you want to put into the trust. And if you're going to try to do an irrevocable Medicaid trust on your own, you're also going to have to transfer your real property into it. You're going to have to do a deed, and doing a deed is again somewhat complex, and you have to meet certain requirements to look at the deed of your house. You'll all that language in there is in there for a reason. And if you miss something and don't get it into that deed, you don't have a proper deed to transfer it into the trust. Now, listen, I'm an attorney, and I'm you're not going to go to you're not going to when you got a medical problem, you're going to go to a doctor. And if you have a legal problem, and these could turn into legal problems. I can't tell you how many times a month, even today, I got a call about this. Oh, my grandmother did this, and she tried to do it on her own, but it didn't work. And we need to straighten it out. Don't be in that predicament of thinking you did this on your own today, and now the God forbid happens somewhere down the road, and when an application for Medicaid gets done and it's denied, you're gonna leave a big mess for your family. So it's kind of penny wise and pound foolish. Now, the last part of the question, or the last question, was about probate avoidance. Now, don't get me wrong. I worked in the court system for a good chunk of my career. I've had friends who have ascended to the bench and are judges now. The courts are swamped. Surrogate courts in particular, especially after the pandemic. They allowed us to electronically file during the pandemic. We all, watched the news and read newspapers and news accounts. We know how many people died during the pandemic. And if those folks didn't plan, their estates had to get administered through the court system. The court system was not equipped to handle that volume. They're still getting through a lot of those old cases. They closed the courthouse down 2.5 years. You couldn't walk into the building. So we're advising a lot of our clients to consider these things, because again, I don't know about any of you, and I intend to do these. I do a trust for myself sometime in the near future when I eventually do retire. I want my assets to go to my children as soon as practical after I pass. I don't want them to have to go to court, probate, this whole probate process. You got to file a petition, death certificate. People have to get notice of your will. If somebody, if you don't leave things equally to your children, the the child that you left a little less to gets upset and they can challenge your will. And, I've been involved in those things too over the years. And it could just get tied up and it's time consuming and costly. My old judge, when I worked in the court system, I worked in the guardianship part, and a lot of times the families fought about who was going to take care of grandma, and they were fighting over everything. And my old boss used to have the lawyers go sit in the gallery and the family members sit at counsel table. And he got off the bench and sat down in front of counsel table, and he said to all of them, I don't know what you're paying your lawyers. Turn around and look at them. And I don't want to know what you're paying your lawyers, but I don't think your parent or your grandparent, whoever was the subject of the case, intended for the lawyers to share in their estate, in their assets. So your differences you may think they're great, but they're not insurmountable to solve without costing you a lot of money. And the overwhelming majority of time, that little speech he made got people to soften positions and settle, because everybody knew what they were paying their lawyers, and it ended quite a few cases.
There's one final question, but I do want to say to our audience that I personally went through a lot of what you just spoke about during the pandemic. And one of the biggest tipping points or issues were that a loved one left the beneficiary blank. And that put us in probate, even though we knew who legally should get it and all of that. But just that little thing, making sure the beneficiary is not blank, making sure it's not your ex-husband from 10 years ago. That happened to me, and luckily I'm still here and I fixed it. But that avoids probate too if you have the beneficiary up to date. So that's just a little
Absolutely.
personal lesson that I don't want anybody here to repeat. And then so we're going to close with Mr. Edwards' question. Can a trust split home ownership to multiple heirs or only one?
You basically, when we do the trust, there's a section of the trust to deal with distribution of assets post death. So, for example, if you're putting real property into a trust, like your question asks, we could have that provision say, I leave my property known as 1234 Smith Street to my children equally, per stirpes. Now, this is going to be the last bit of this, the per stirpes. Per stirpes means bloodline distribution. So if, God forbid, one of your children predecease you, it would go to their children, not to their spouse. If a child predeceases and has no children, it would go to your remaining children. So that per stirpes language is generally how we do it. And then again, you could also do it in percentages. You could, I leave 25% to my son, 25% to daughter A, and 50% to daughter B. So there's a lot of flexibility in how you can distribute in a trust post death.
Thank you so, so much. I would love for everyone to give Mr. Lamberti a virtual applause.
All right. I appreciate
We
it.
can all do that.
Thank
This
you. Wow, look at
was
that. Very nice. Thank you.
valuable advice, not just value in terms of knowledge, but I know this is value financially as well. And your alma mater thanks you. Your alma mater is very appreciative of you. And this was just amazing. I know it's not exciting and fun information, but it is so, so important as someone who personally went through a lot of the things that Mr. Lamberti spoke of. I have been on a mission to share with friends, alumni, family. I'm doing a similar workshop like this to one of the organizations I belong to because it just, you don't want your family to break up when you're no longer here. And there is, unfortunately, a lot of potential for that. And I don't want
True.
that to happen to you.
True.
Anyway, I'll get off my soapbox. Mr. Lamberti, thank you. I
Thank you.
appreciate
You're quite
you. I
welcome.
know our colleagues on the call appreciate you as well.
You're quite welcome. And reach out again if you think you need me.
I will. Thank you. Good night, everyone. I know you could have been anywhere tonight, and I am so appreciative of you being here and sharing this hour with us. So thank you and have a wonderful night, wonderful holiday season. I can't even
Yes.
believe I'm saying that.
Yeah.
So, and one more thing, homecoming is on November 21st. So keep an eye out for the flyers and the social media. If you can make it November 21st in the gym, 5 o'clock, we'd love to have you.
Okay.
Open bar and free food.
Okay.
All right. Thank you, everyone. Good
All right.
night.
Good night. Thank you.